Hi and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Palomo. On this podcast, we discuss all things estate planning and elder law and anything else we want to talk about. Well, today we actually are going to talk about an estate planning and elder law topic. This is based upon feedback that we have been getting from our listeners on topics that they want to see. So if you have any ideas for topics or anything you would like me to discuss on this podcast, please let me know. Send me an email, give the office a call, reach out to us, let us know. We are more than happy to tailor these podcasts to whatever you want to talk about, whatever you want to listen to. Certainly no problem about that at all. And this one is purely coming from the listeners. The comments that we have been getting are, well, gee, Jeff, aren't trusts for the wealthy, aren't trusts for the really, really high end, and what would be the advantage of putting my house in a trust? So on this topic, or this podcast, I want to talk specifically about putting a house in the trust. We won't necessarily discuss other assets today. We have covered that on other podcasts. And specifically, we train through the use of the Radio Flyer Red Wagon, which is over my left shoulder here. I won't necessarily pull it out today because we've done that on other podcasts to show the mechanisms and how it works. Today, I just want to have a conversation around what are the benefits of putting a house in a trust? Why would you do that? Are there any downsides, things you should know, and those kind of things, and we'll certainly talk about that on this show. But as always, we offer our estate planning workshops on a weekly basis in York, on a bi-weekly basis in Lancaster, and we always have them on a link that you can watch from the comfort of your home. Remember, you should not take legal advice from this show or any other show for that matter. If you need an attorney or are seeking legal advice, please contact an attorney in your area. If you are in the state of Pennsylvania, I would be honored to assist you. Our number is 717-845-5390, or check us out on the web at www.palomoassociates.com. We would certainly be honored to assist you and your family if you're in the Pennsylvania area. If not, please seek an attorney in your area who has an expertise or a specialty in the area that you are looking for. All right, now that we got all the disclaimers out of the way, let's get into the podcast. So, as we have discussed previously, trusts are a contract between three parties: the grantor, the person who creates it; the trustee, the person who controls it; the beneficiary, the person who receives it. Now, as long as we're not talking about tax trusts, and as long as we're not talking about trusts where people are trying to get the money out of their estate, we are doing this podcast in 2022. In 2025, the federal estate tax limits are set to change. Currently, you can die with $12.06 million. Your spouse can die with $12.06 million, and there's no federal estate tax, right? The rate's 40% if it applies, but if you're under that, there is no federal estate tax. In 2025, it's set to go back to $5 million per person, plus inflation. We're predicting that's going to land somewhere around 5.8 and 5.8, which for us, for husband and wife, what is that, 11.6. So it's still a pretty high number if you're married. For 5.8 for an individual, pretty high, but you may have people that who may have that issue. So in a couple years, the planning may change a little bit, or if Congress decides to change it altogether, then we will deal with that when it happens, and we will certainly have a plan in place. But for now, that is not the case. So currently, we are able to use trusts where the grantor is the trustee. They do have control. Now, what that means is it will be included in their estate. But as long as they don't have more than those huge numbers we just discussed, it really won't matter. Pennsylvania transfers on the actual transfer. They tax depending on the person who's receiving the money. So if you're transferring to a spouse in Pennsylvania, it's a 0 rate. Notice I didn't say it was exempt, did I? I said it's a 0 rate. There was a time in Pennsylvania where it was a 6% tax. So that's a pretty hefty tax to transfer assets to your spouse. Currently, it's 0. We'll wait and see if that changes. We'll wait and see if they end up trying to tax the spouses. Personally, I just can't imagine they would. But I understand that if you're in a financial crisis situation, you'll make decisions sometimes that don't please people to generate the revenue you need. So I guess we'll just wait and see. Currently, it is 0. Lineal descendants, 4.5%. That's children, grandchildren, parents, grandparents. Siblings are 12%. So that would be out, would be siblings, 12%. And then 15% is to anyone other than any of those people, right? Including nieces and nephews at 15%. So I know that sounds like a lot, but in most cases, you're transferring to a child, which is 4.5. I don't really consider that horrible. Yes, some other states do have exemptions, 500,000, $1 million before they start taxing, but their tax rates are a lot higher, usually 30 to 40 to 50%. So I actually think we kind of get away with one in Pennsylvania, as you've heard on other podcasts, and if you've ever heard me speak, you know that I kind of feel like the Pennsylvania inheritance tax, the analogy I use is that it's like a pimple on your back, right? It's annoying. It goes away. It comes back. It goes away. And then it just annoys you again. But other than that, it really, to me, is not a huge deal. You get to step up in basis. So what that means is if I control the property in a trust that I control, or I own it in my name alone at the time of my death, it will transfer. It will go to, let's say, my children, right? My beneficiaries, and they'll pay at that 4.5% rate. But when they receive it, they get the fair market value on the date of death. That's huge, right? Because historically, houses have accumulated and appraised and raised the value tremendously from when you buy it to when you sell it. So to have the children receive it at the basis or at the fair market value on the date of death, if they go to sell it, they're not going to have to pay huge capital gains taxes. They're going to pay probably 0 or very little, because it would just be the increase from the date of death. So generally in a month or two, it doesn't go up that much. So you're not going to be talking significant changes there. Now, if the person were to gift the asset during their life, and those of you who have watched me do my 3 lands and presentations, you know that I'm not a big fan of gifts. I feel like it's a 4-letter word, or gift, I should say, and I don't think that people give it enough credence and credibility as to how risky it can be, right? Which we won't really necessarily focus on today, but as a general statement, I'm not a fan. There's places for it. There's certainly planning reasons for it, but only in certain circumstances. In the context here, if you give your child your house, the basis that they receive is the basis that you had. So if you paid 20 grand for something and it's now worth 200, which with housing, if you bought it, in the 70s and 80s, that's a real possibility, which a lot of people did. Now you got a huge appreciation amount there. You got a huge amount of gain. Well, if I receive that property during your life, you might avoid the 4.5% as long as it's in my name for more than a year. But by avoiding that 4.5%, that means that now my basis is 20. So if I sell it for 200, I pay 180,000 in capital gains tax. And the rates are, depending on the income of the individual receiving it, but it doesn't take a ton to get to 23.8% tax. So I always say, would you rather pay 4.5 on 200 or 23.8 on 180? I mean, of course you'd rather pay the 4.5 on 200. So obviously there are exceptions. Obviously it's not all one size fits all, but we have to pay attention to that part of it, right? It's not as common as it used to be that children are living in the houses of the parents. If you live in the house for 2 out of 5 years, there is an exemption on the gain up to, I don't know, I think it's like 650,000. But that's not the case if it's not your primary residence. And for most children, it's not their primary residence. So you want to be extremely careful. The advantage of putting the house in the trust, I mean, let's think about it. what's the biggest asset that most people have? And maybe outside of retirement, but sometimes even including retirement. Yeah, it's the house. That's the asset that holds the most value. Now, what I hear all the time from people is, gee, Jeff, isn't the house exempt if I go into a nursing home? Well, the general answer is no. Just out of the gate, let me just say no, it's not. Now, there are ways that we can transfer it to a spouse, and it can be exempt for the spouse. But I'm saying that intentionally because most nursing homes and most people who do Medicaid planning kind of on the side or as a whim, they don't know that they should be taking the house out of the spouse's name and putting it in the other spouse. They think you should leave it joint. No, if it is jointly owned and the person who is well dies first, it's now transferring to the person who's in the home. And now it's not exempt anymore. Gee, Jeff, can't you exempt it with the intent to return home? Sure, but when they die, the state is able to lien the property up to the amount of care that was provided. So we end up losing it anyway, right? So as a general rule, no, it's not protected. And there are steps for a spouse that you have to take in order to protect it. But furthermore, you don't know if your spouse is going to be alive. I know that currently they might be, and that's great. And I know they might be healthy, but that doesn't mean that they may pass away in the meantime. And if they do, you now lose the ability to protect that house. So what we want to do is we want to put it in a trust more than 5 years before you go into a nursing home. Gee, Jeff, when's the best time to plan? Now, right? My actual joke is 5 years and 1 day before you go into a long-term care situation. And then they say, well, how do you know that? What's the next best time to plan? And that's now, right? If you put the house in the trust, now, who owns the trust? Who owns the house? The trust. Who is in control of the trust, right? The trustee, who can be the grantor. So now you've got the individual creating it in control of it, meaning that person can live there, nobody can kick them out, they can buy another house, they can sell that house, they can do what they want in the trust. The problem with us in our society is that we were always told and taught that the American dream is to own a home. I don't agree. And I've said this on other podcasts. I used a wagon to highlight my story here, but I think the American dream is to be the only person who can use the house, the only person who controls the house, the only person who can enjoy the house. But nobody else can. And nobody can take it, right? If you own it outright and you end up in a long-term care situation, you get in a horrific car accident, you can lose those assets, Now, there are some protections for marital properties. Again, I'm not going to get into those details. But as far as it relates to long-term care, there is not. And yes, you can transfer it to a spouse as long as they're alive. But then what if that spouse gets ill, right? People wait thinking they can rely on the spouse, and now 5 years becomes impossible. So now we end up making that house at risk. If we get the house in it early enough, 5 years goes by, it's fully protected. And you still have the right to use it. You still have the right to enjoy it. You still have the right to do everything. You can still sell it. You can still buy another one. You get to do everything that you did before. Usually somebody raises their hand at this point in the workshop and says, gee, Jeff, why wouldn't everybody just do this? And the answer is people who know about it do. People who understand it do. We do a lot of these in our practice. A high volume of these types for the house specifically. Why? Because that's our biggest asset. That's the biggest risk to being lost. And someone once asked me, well, if you're able to protect stuff for a spouse, why would you bother with a trust? And I didn't hesitate. I didn't blink. I looked them straight in the eye and I said, because that's the guaranteed result. If you are relying on a spouse still being alive to rely on the spousal protections, you're taking a big chance. You're taking a big risk. Why? Because they may not be there when you need them. And if you lose the spouse, the assets are absolutely at risk. And Who knows if the law is going to change, right? We don't know that. These crisis rules could change any day. But even if they don't, I still stand behind the decision to put the house in a trust. It gets it protected. And yes, because I control it, I still pay inheritance tax. But as I said earlier, I want that step up in basis. So I get the control that I want. I get the step up in basis that I want. I get the asset protection that I want. It's a win-win-win. We have had no issues with Clean and Green. The counties that we did, we reached back out to them, we notified them in the statute, and we were able to get it through. So let's talk about the elephant in the room. Gee, Jeff, what if there's a mortgage on the property? Well, technically, you should not put it in a trust, right? Technically speaking, the mortgage will say there's a due on sale clause that says that if you transfer an interest in the property, we're able to, trigger the due on sale clause and have you pay it all at once. But the more practical answer, and usually when you go to national conventions and you talk to other lawyers who do this on a daily basis, we all sort of agree, which is in contract law, you have to give the person, before you can get damages, the right to cure it, the right to make it right. Well, how do you make it right? You put the house back in their name. That is possible, that is doable, and it is something that can occur. And the way we look at it is, because we have the right to cure it, we have the right to put it back in their name. In a lot of our cases, what we're dealing with, our clients have the ability to pay it off if they had to. They're using it more for convenience because the rate was so low when they did it. But if they had to pay it off, they could. But even if they couldn't pay it off, we still have the ability to cure it by getting it back in their name, which we can do. I won't bore you with the specifics or the details in this podcast, but it is definitely doable. We have had no issues. We do hundreds and hundreds and hundreds of these, have not once had a problem. Why? Well, primarily because no bank is in the courthouse on a daily basis checking to see if you transferred an interest in the property. If you're paying that mortgage on a regular basis every month, they're going to be cool, right? They're not going to care. If you stop paying it, they're not going to be. And if you ask for permission, they're going to say no, right? So this is one of those dilemmas that you have to kind of decide for yourself what's right for you. As a general statement, we feel like because we have the right to cure it, we're not harming anyone. The bank is still in first position. The bank still has the ability to lien the property, even if it's in the trust. Why? Because they were already a creditor. They were already in place. The biggest thing you need to know about trusts is that you cannot use trusts to commit fraud. If you know of a creditor or should know of a creditor, it's too late. You can't put those assets in a trust. We get calls all the time. I'm a doctor. I was sued for malpractice. I'm a truck driver and I was in a car accident and I killed 4 people today. It's too late. You transferring assets into a trust after the incident occurred and you knew or should have known that there's a possibility of somebody wanting to sue you, that's fraud. We are not going to commit fraud. We are not going to do anything to get ourselves in trouble, right? So the only thing in that instance is if a bank ever called and said, hey, we found out about this, we're triggering the due on sale clause. The one time it did occur was because one of my clients actually called the bank. She had dementia. She was 4.5 years into the 5-year look back period and made a call at 3 a.m. saying, I think I forgot to tell you. The attorney for the bank called me and we talked. I explained what type of trust it was and what we were doing and how far into the look back period she was. She understood that that person still controlled it, that it was still in that person's SOCH. They said, no problem. We're good. We're not going to pursue it. And beyond that, we've not had any other issues. The other topic that I want to talk on briefly is once a house is in a trust, it is difficult to get a loan on the secondary market. So most banking or financial institutions will sell their loans on the secondary market. A house in a trust cannot be sold on the secondary market. So we go to local banks. We go to, there's one national bank that we work with and one local bank that we work with that we've been able to get loans if people want to get a loan on the house. Now, generally speaking, A lot of people who are doing these have other assets, so that's not always an issue that they're going to be looking to borrow money. But we have, knock on wood, had success in getting people loans in the trust with local banks or with one particular bank that keeps it in-house, doesn't sell it on the secondary market. So far, so good. We've not had an issue with that being a problem. If somebody is looking to borrow money and they want it to be on the secondary market, unfortunately, you're not going to be able to put the house in a trust. But as I said, we've not had anyone thus far who hasn't been able to get one. They may choose not to do it, but they've been able to get one, and the rates were very competitive. One person in particular just decided that she didn't want to deal with a national bank from New York, so no problem. That was her decision. There was another local one that made an option as well, but she chose not to do it. But again, that was more of a choice rather than, in the fact that she couldn't do it. But anywhere that's going to sell them obviously will not be able to do it because you can't do that. But, hopefully you're not using all this money anyway. The point is to get the house protected, keep it there, and that way you're guaranteed to pass it on to your children and not take a chance on losing it to long-term care costs. So I could go on for hours about this topic. I am very, very adamant, very strongly opinionated about this one. Other areas I feel good about and I certainly believe in, but this is one that I don't hesitate about. Getting that house protected, you still get the step up in basis, can't lose it to long-term care, you're still able to sell it if you want, you're able to downsize, you're able to supersize, do whatever you want with the house. But the goal is that we keep it protected. If you sell it and you want to buy another one, we still use the money from the trust. We still buy the next one. It is not an issue to buy and sell through the trust as the trustee. And if you get older and don't want to be the trustee, then we can appoint your child or someone else to act on your behalf. But as long as you're able and competent to do so, you certainly can do that. So, well, that's a little bit about trusts. I want to remind you not to take legal advice from this show or any other show. If you're looking for an attorney to help you with this type of transfer, please contact someone who is a certified elder law attorney in your area. If you're in Pennsylvania, we would be honored. Please give us a call, 717-845-5390, or check us out on the web, www.belomoassociates.com. Thank you so much for watching this podcast on the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we talk all things estate planning and elder law and anything else that we want to talk about. Very good. I can't thank you guys enough for joining me today. I hope you learned something about houses and trusts and the benefits of doing so. I am a big fan, and as I stated, it is the only guaranteed result. Relying on crisis rules, not a great idea. Why? Because you may lose the spouse, the rules may change. There is no guarantee in that instance. You get that house in early enough, 5 years goes by and you are protected. Thanks for joining us on the show. We look forward to seeing you on the next one. Have a wonderful day.